Welcome to today's presentation. My name is Uche Herome. The topic of this presentation is medical liability. This presentation is very important and it is made for the hospital patient at Ipswich Hospital, Queensland. The medical liability topic is an important topic because it has to do with the life and safety of individuals. According to Linda Peckle in her article Challenges of Medical Liability Reform in a Rapidly Changing Healthcare Environment, she stated that medical liability is one of the most troubling issues in medicine today, resulting in a heavy burden of patient mortality and injury. Dr. Kristen Tressler, in her article titled Medical Negligence Lawyer: What Every Patient Victim Should Know, stated that Australia has a very high rate of clinical error, with many incidents serious enough to justify legal action by medical negligence lawyers. She went further to state that Australia has one of the highest incidences of negligent clinical care in the developed world, and according to a Quality in Australian Healthcare study, 18,000 people may die every year in hospitals through preventable medical negligence in Australia. 50,000 people suffer from permanent injury annually as a result of medical negligence in Australia. 80,000 Australian patients per year are hospitalized due to medication error. Luns in Tort Case and Commentary stated that the relationship between medical practitioner and patient is one of the oldest in which a duty of care was recognized. Now, according to Jim Burton and Reno Burton in their article Causation in Medical Litigation and the Failure to Warn of an Inherent Risk, they stated that patients who have not been warned of risk in the course of treatment traditionally has to establish that had they been properly informed, they would have opted for a different path. Medical negligence claims are not restricted to surgical error and can be made for failure to warn or lack of informed consent. While there are other actions that could be brought for medical negligence liability, this presentation will focus on the issue of failure to warn of a risk as an action for medical liability. If as a patient you feel that a doctor is treating you or has treated you without warning you on the risk involved in the treatment, you can bring an action against that doctor. There is a provision in Queensland law that allows you to make a case for failure to warn. The law with regards to failure to warn requires that the elements of negligence be established. You must show that the doctor owes you a duty of care. You must show that that duty of care was breached by the doctor. You must show that the harm or injury you suffered was caused as a result of the breach of duty, and that there ought to be damages for the loss you suffered. The first element you have to show is that the doctor owe you a duty of care. Now, this principle was established in Rogers and Whittaker. The court in Rogers and Whittaker held that it is a duty of a doctor to care for his or her patient by way of treatment, diagnosis, and providing him or her with necessary information. In other words, when you go to a hospital, the doctor that treats you owes you a duty of care. That is to say, doctor-patient relationship. In Papa and Sullivan, the court there found that the defendant was guilty of negligence because the defendant a patient in non-deligible duty. This is because you are staying in their facility, but we are not going to dwell on that area. The second element you must show is that the doctor breached his or her duty by failing to warn you of the risk in the treatment. The court in Rogers and Whittaker rejected the Bolam test, which makes it a rule in medical negligence that if the doctor's practice is approved by an accepted body of practitioners, it will be a defense against negligence complaint. The court in Whittaker held that the relevant duty of care was to exercise reasonable care and skills in respect of examination, diagnosis, treatment, and the provision of information. Section 21, subsection 1A and B of the Civil Liability Act specifically deals with the issue of failure to warn, where the doctor has a proactive and reactive duty to warn of a risk in treatment. The provision in section 21 states that a doctor does not breach a duty owed to a patient to warn of risk before the patient undergoes any medical treatment that will involve a risk of personal injury to the patient, unless the doctor at the time fails to give or arrange to be given to the patient the following information about the risk. Information that a reasonable person in the patient's position would, in the circumstances, require to enable the person to make a reasonably informed decision about whether to undergo the treatment or follow the advice. Information that the doctor knows or ought reasonably to know the patients want to be given before making the decision about whether to undergo the treatment or follow the advice. Section 9, subsection 1A, B, and C provides a test for breach of duty for foreseeable risk that was not insignificant and a reasonable person would have taken precaution. Depending on the nature of the treatment, I will argue that there is a foreseeable risk of injury or death when there is a treatment on a patient. And as a trained doctor, he or she ought to know that injury or death might happen and should let the patient know of the risk involved in the treatment. Let me talk about the risk that is insignificant. Any doctor's treatment on you in a hospital cannot be said to be insignificant because patient will not have come to a hospital, or you would not have come to the hospital if the issue was insignificant. The test of reasonable person is left for the court to decide. I will argue that a reasonable person is somebody that is not a minor or who suffers from mental illness or cognitive impairment. A doctor that is working in a hospital cannot be said to be of any of these disadvantages. And precaution means that all necessary steps were taken to ensure safety. Therefore, if your doctor, who is a reasonable person, before commencing a treatment on you, fails to tell you the risk you may face during the course of the treatment in order for you to make an informed decision, that doctor could be in breach of the law in Whittaker and the Civil Liability Act of Section 21, subsection 1A and B. The third element I will emphasize is on the third element that I will emphasize is on the is for you to show that the injury or damage you suffered was caused because of the failure to warn of risk of treatment. That is causation. There are two elements of causation in section 11 of the Civil Liability Act. There is the factual causation, which says that the breach was a necessary condition of the occurrence of the harm, meaning that the breach caused the harm. The second element is that the scope of liability, which states that it is appropriate for the scope of the liability of the person in breach to extend to the harm so caused. Section 12 places the burden on you to prove a breach of duty on a balance of probability, that is likelihood, that the doctor's failure to warn caused the injury. Now, in Chappell and Hart, the plaintiff argued that if she had been warned, she would have considered other options and have a surgery on a later date. The majority court held that the defendant caused the damage. The decision in Chappell concurred with section 21 of the Civil Liability Act. If the doctor fails to warn you or give you the information that concerns the risk involved in the treatment and it results to complication, injury, or death, the failure to warn will be a factual causation. That leads us to the but for test. But for the doctor's failure to warn the patient of the risk involved, the injury would not have occurred and the patient would have had other options. After you have successfully shown that the doctor owes you a duty of care and that he breached the duty and the harm you suffered was caused by the breach of duty, the next step you will take is to seek for compensation for the harm you suffered or the loss you suffered. That leads us to the final elements of damages. Damages is a compensation paid for the harm caused. Apart from the difficulties in succeeding in medical negligence case, assessing the damages is also a difficult task. You can claim damages for economic and non-economic loss. Economic loss include loss of wages, income, out-of-pocket expenses, transportation, medical expenses, and other domestic services. Non-economic loss refer to the pain, anguish, and suffering as a result of the harm and injury you suffered. Section 28 provides